respectfully stated, each of you swore an oath to uphold the Constitution. And if you don't understand the provisions that you swore to uphold, then you're not fit for office. I'm here today to assert my rights to instruct and to remonstrate unlawful conduct by address. As members, you have inherited some incredible mistakes from your predecessors. Mistakes that have unlawfully altered our form of government and that cause great harm to the citizens of the state. Our first step must be to correct the Tennessee Constitution on these houses' website held out to the people. I hereby instruct you to correct the false version of the Tennessee Constitution. Your continued refusal to do so is treason to the Constitution, and it's violation of your oaths of office. The last phrase of Article 1, Section 23, I have viewed the original 1870 and 1834 Constitution with my own eyes in the archives. The last phrase says, by address or a remonstrance, or remonstrance. We have a choice. And that language has been altered in the PDF version held out on the Secretary of State and the General Assembly websites. My name's John Gentry, and I represent the interests of all citizens of Tennessee, seeking mandamus to compel the General Assembly to hear and decide a remonstrance, aggrieving the government acting in violation of the state's Constitution. The seal of the judiciary reads, let justice be served that the heavens may fall. And that's what this case is about, is restoring justice to all citizens of Tennessee. And justice is defined as the fair treatment of people. Citizens cannot have justice without fair and impartial courts, and we cannot have fair and impartial courts without judicial oversight and accountability. And citizens can also not have justice without the voice protected in the right to petition for redress of grievance by address or remonstrance, but that right is oppressed. The fact that I'm the first one since 1850 to exercise this right is evidence the right is oppressed. The conduct of the government thus far evidences that the government of the state of Tennessee is no longer Republican in character or form and has forsaken the Constitution that created government. I find it absurd that I have spent more than a year in court proceedings and thousands of dollars defending constitutionally protected rights and demanding that the false version of the Constitution be corrected. The trial court and defendants have suggested that the defendants don't have a duty to display the Tennessee Constitution on their website, and therefore the court does not have power to order to a correct version be displayed and presented to the public. That is failed logic. The chancellor, the defendants, opposing counsel, as well as this honorable court, all have sworn oaths to uphold the state constitution. That oath creates the highest duty. And knowingly holding out a false version of the Constitution is a violation of oath. And since they have a duty to support and uphold the Constitution, the courts have the power to order performance of duty, and the court should order that the false version be removed from their website or replaced with a correct version. Again, respectfully, it is absurd that I have to bring a cause of action against high-ranking state officials to correct the PDF version of the Constitution held out to the people. And according to this court's own opinion, that false version is a constructed fraud on the entire citizenry. And I cited that case in brief.
The petitioner then filed an amended petition that asserted the same claims but raised a new claim concerning the typographical error that exists in the Constitution that is posted upon the General Assembly's website.
Has the typo been corrected?
To be honest with you, I have not gone and looked to see if it has been corrected. The trial court found that there was nothing in the Tennessee Constitution that established a duty upon the General Assembly to post a copy of the Constitution on its website in the first place. Nor did it find anything in state law that imposed a duty as well. And without such a duty, the trial court found that it didn't have the jurisdiction, again, to issue a writ of mandamus to the legislature to require it to either remove the version posted on its website or to post a corrected version.
Well, if you're going to post it, you ought to post it right, don't you think?
I would agree, Your Honor, that you ought to have a correct. I will note.
Be sure to unmute.
Yeah, thank you. I just checked the General Assembly website. The Constitution is still incorrect. It has not been corrected on the General Assembly website yet. That cause of action alone that I added to my amended pleading should have been addressed in the trial court. They have a duty to not deceive the citizens with a false version of the Constitution. Opposing counsel says that I didn't establish my right. I was deceived through a constructive fraud, and I cited the opinion in this case that holding out a false document like that, where I didn't know that I had a right to address orally. I didn't know that I had that right. So I was deceived, through a constructive fraud to not know that I had a right to address the government.
You were deceived by the typographical error or whatever it is.
Absolutely. I was arguing in court that by address of remonstrance means they have to address it, and that's when Ms. Kleinfelter said no, it's by address or remonstrance. I'm like, oh, good. Now I know I've been deceived by my government to not know I have a right to address them. This right of petition arises out of the 12th century Magna Carta, and in the 1640s or 1640, the House of Commons determined that commoners have the right to prepare and present petitions. And I have shown you in my appellant's brief the House Journal from 1831, where members presented petitions. You have to be heard. That's essential to due process, is to be heard. And yes, the opposing counsel is correct that the General Assembly can make their own rules. Well, they did, and they've had those rules in place for many years. And Rule 15 and Rule 22 says that petitions shall be received and read at the table. So they have failed to perform that duty. So I clearly established a right. I clearly showed that they had a duty to this. An important part of why the founders put in there to petition by address or remonstrance is stated by the Supreme Court of the United States. Publicity is crucial to justice. That any star chamber dark court proceedings that occur out of public view leads society to question, whether justice was served in that case. And so it is essential that these petitions be read at the table. It is essential that if citizens have something worthy of addressing the body, that they address the body. It was a clear failure of duty. They have established House rules of order that say petitions shall be received and read at the table. And it would be the same thing as an ex post facto law to go back and change, what their rules are to deny me, from having my petition read at the table or allowing me to address. The constitutionality of any issue, and it's in this court rules, I believe I referenced it in my reply brief, the constitutionality of any statute or any rule can be raised at any time. And opposing counsel has provided no supporting authority to say that I can't raise these issues at any time. And, if we want to kick the can down the road, I'm happy to go do a remonstrance with the Tennessee Supreme Court and challenge Rule 10b and challenge the House Rules of Order. I'll do it as a memorial and remonstrance in the Tennessee Supreme Court. I am tenacious. I'm not going to give up on it. I think it's wrong. I think it oppresses the rights of the people. So, let's not kick the can down the road. Let's address the matter right now. What I'm trying to do here is play the middleman between government and the people. There is incredible unrest in this country And there is incredible unrest at the tyranny and oppression by government of its citizens, and there is no relief valve. This right of petition is the relief valve, and we need to start doing it now. It is fundamental to our form of government. United States v. Cruikshank, 1876, the right to petition for redress of grievance is fundamental to government, Republican in character or form. And we have to restore that voice and restore justice to our people. Thank you.
Thank you, Mr. Gentry and General Kleinfelter, for your arguments. We will take this matter under advisement. Mr. Hibner.
This honorable court is now in recess until 11 a.m.